I would like to welcome you to today's expert mini briefing webinar, Privacy and Data Security in Cloud Outsourcing, Battle the Myths with Those Tips. My name is David Goodstein and I am a webinar coordinator for the Outsourcing Institute. It is our pleasure to be the co-host of today's event with Murali Pasbulati. Before we commence today's session, I would like to say a few brief words about the Outsourcing Institute for those of you who are not familiar with us. The Outsourcing Institute is a professional association dedicated to providing the independent best practice tools, roadshow events, and networking opportunities for all forms of outsourcing. Located at outsourcing.com, we have 70,000 members globally. We specialize in providing low-cost and no-cost alternatives for outsourcing buyers in need of RFP tools, vendor selection assistance, training, as well as general support and coaching. For those who are in the market in this space, we offer an array of targeted sponsorship and promotional opportunities. Our sister company, CMS, provides recruiting services for those seeking to hire outsourced professionals experienced at buying, selling, managing, or consulting in this arena. Our contact information is at the bottom of the screen for those who have any questions. Without further ado, I will now turn it over to today's speaker, Murali K. Pasbulati, Esquire, Legal Counsel, and he will say a few brief words.
Thank you, David, for your kind introduction and also for ably seeing this process through. I also would like to thank the Outsourcing Institute and Frank Cassell, its president, for sponsoring this presentation. It is a pleasure to be able to discuss these critical issues, and thank you all for tuning in. Now, before we dive into the presentation that surrounds privacy matters related to cloud computing, I thought I would give a quick summation of what we are attempting to achieve here. Firstly, while this is by no means a comprehensive capture of all the relevant legal issues and solutions concerning privacy and data security matters in the cloud space, it still ought to be a good starting point to arm yourself with some facts to battle the myths that you probably already encounter in your business. The objective here is to identify the common myths and also provide you with the myth busters so you could use it practically and in the real world as you see fit. Cloud computing, we all know, is here to stay, but the persistent myths concerning data security and control are a major obstacle to realizing its full potential. This is my attempt, albeit in a very small way, to help cloud providers educate their customers on the privacy and data security aspects in cloud computing. Now, secondly, let us quickly define a few terms that we will encounter in the course of the presentation. Now, these terms are also key to understanding privacy and data security matters. The first term is personal data. Now, personal data is any information relating to an identified or identifiable natural person. So think social security numbers, names, date of birth, addresses, etc. when you talk about personal data. Now, the second term would be data subject. It refers to an identified or identifiable natural person in the context of personal data. The third term that we are going to see is data controller. It is generally defined as the natural or legal person, public authority, agency, or any other body which alone or jointly with others determines the purposes and means of processing of personal data. So for our purposes here, the data controller is the company or the customer. Now, the final term that we need to know is data processor. And data processor is a separate legal entity with respect to the controller that processes personal data on behalf of the controller. Again, for our purposes here, a data processor is your cloud provider. Now let's proceed to the substance of the discussion and presentation. Now, the first myth that we just generally grapple with is cloud computing is a paradigm shift. Now, this is perhaps the biggest myth and obstacle that cloud providers face with customers. Contrary to all of the general marketing hype, it's important to reassure key decision makers in a company that this is not something so radical and new that they would be actually pioneers in this space. No one really wants in business to be the first to pull a trigger on a new and untested process, especially those who are making these calls, balancing the risk exposure and the return on investment. So instead, I suggest that we always accentuate the benefits of the cloud model the ubiquity of its use in the industry, and also, of course, reiterate the savings and productivity gains that come from adopting it. While cloud computing is growing by leaps and bounds for the past few years, it must be noted that this is not a brand new breakout technology, but rather something that has been around in various iterations. So think ASPs, for instance. Also, for the non-technically inclined decision maker, it helps to point out that he or she has always stored their personal emails and photos in the cloud. Clearly, your typical decision maker would find it a lot easier to know that this is a term that is used simply for scalable pay-as-you-go type service via the internet. Now, let's go on to the next myth, which is generally about cloud computing is bad for privacy and data security. Now, this myth has many dimensions of submyths that goes along with it, as seen on the slide. And related to this, you would notice, for instance, on the slide, there are three very distinctive submyths that accompany it, which is that data transfers via cloud poses steep security challenges, security and privacy challenges, or two, that post 9/11 data is not safe in the U.S. Due to the new and onerous national security laws that have come about, or three, that cloud providers have absolute control over customer data. Now let's go on and examine each of these myths or claims. Actually, there is no basis to presume that cloud computing is any more riskier than, say, a wide range of risk exposures that customers already face with respect to their data. In fact, cloud puts security in the hands of security experts. In most instances, it's definitely more secure than customers standing up a security framework by themselves. This is because cloud solutions employ the highest standards of scrutiny, the latest technologies, and leading experts to protect the data. As cloud providers, you enjoy economies of scale that allow for continuous improvements to the security posture. It is important to emphasize this aspect because it gets lost in the steady drumbeat of the news we receive these days regarding data breaches and hacking and so on and so forth. Now, dealing with these submyths, one of them is as for the data regarding the international data transfers. As for data transfers, it is important to note that this is already happening pretty much every day. Again, it's helpful to bring some perspective and relate it to the business realities of today. We are routinely exporting business documents such as spreadsheets, emails, memos, and other information in this globalized economy. So there is actually a constant transaction occurring even with respect to, say, personal data by companies, whether they host it themselves or use a cloud provider. Now, a submyth, which is very related to the earlier one, is that concerns the data transfers to the U.S. in the age of the Patriot Act and other national security laws that have been passed in the wake of 9/11. Firstly, with regard to Patriot Act, it must be understood that it's primarily a terrorism and money laundering fighting tool that allows for the U.S. law enforcement agencies certain special powers. Now, most of the time, these powers are not relevant when it comes to the vast data that is generally transacted in cloud computing arrangements. Secondly, in those instances where the U.S. government actually is interested in the data, they actually don't need to break into a cloud provider to get access to this data. They usually go straight to the foreign government or have through any of the number of complex intergovernmental arrangements that governments generally have. And thirdly, if the data controller is actually not based in the U.S. or has no strong nexus to the U.S., the chances are that the U.S. government would not probably pursue this data regardless of whether the data is stored in the U.S. or elsewhere. Finally, it also must be noted most of the time these objections are a political red herring or a protectionist measures usually put forth by interested parties such as unions and other bodies which are not actually concerned with data protection. Now, the other myth, submyth I should say, concerns the last of these is related to that cloud providers cannot give up control to their customers and instead retain absolute control of the customer data. Here it is important for customers to realize that cloud providers do not and must not seek absolute control of the data. This is because the more control a cloud provider acquires, it could be deemed a data controller, which then brings a whole host of obligations and responsibilities upon it. Neither the customer nor the cloud provider wants such a change to take place. In fact, if the cloud provider did in fact qualify as a data controller, then the customer would technically be violating statutory provisions and privacy obligations that they have taken in regard to data sharing. Therefore, it's very important for both the provider and the customer here to work towards an arrangement that keeps the cloud provider limited to the role of a data processor. In other words, both parties have very distinctive roles and they need to stick to it. Now let's go on to the next myth, which is regarding privacy and data security, and that is all on the cloud providers. Now this is a myth that is persistent but so weak on the facts. In reality, the data controller, that is the customer, is usually primarily responsible for compliance under the various privacy and data security laws. So typically your cloud provider has only two duties really under privacy laws. One is to follow the instructions of its customer and ensure that the data is secure from unauthorized access, and at the same time ensure data security, which again falls broadly within the ambit of the customer itself. So a customer and a cloud provider really must sit down and clearly discuss what types of data are being involved in the transaction and what are the compliance implications here. Depending on whether as a cloud provider you're offering, let's say, specialized application solutions or services, it may be required that you provide certain types of sensitive data through encryption or other methods, but these measures may also be required of the customer anyway. So there is again no blanket requirement that as a data processor, that is you as a cloud provider must be left with the sole responsibility of ensuring privacy and data security. So now let's go on to the other myth, which concerns US and the EU safe harbor. For those who are not clear about it, it is simply the United States and the European Union which struck a deal for data transfers from Europe to the US. Now, US, whether one is deemed a data controller or a data processor, the safe harbor is actually very clear on this point. It's applicable to both parties and not limited just to the controller, that is the customer only. So in fact, any entity that meets the standards set forth under this EU safe harbor rule would be deemed adequate for purposes of handling personal information of European Economic Area residents. In order to get the safe harbor certification, you don't need to be only a data controller. Of course, any company that is contracting with a cloud provider to handle personal data flowing out of Europe must ensure that the US-based cloud provider is certified before it can actually pass along that data. Now let's move on to the other myth regarding records, and that records must be actually maintained locally and not in the cloud. Now, while it's true that some types of data are required to be maintained within a country under certain applicable laws, this is not generally a requirement for the vast majority of data involved in cloud transactions. In fact, even such data that may be required to reside locally, there is no strong prohibition against transferring into the cloud as long as you keep originals and backups records that are kept in place in the local jurisdictions. Now let's move on to the next myth, which is regarding customers, which says that customers require unbridled audit rights to vendors' data centers and systems. Now, while it's true that customers need to reserve a right to audit cloud providers' compliance measures, it's also important to point out that you cannot open your data centers or information systems without qualifications and reservation. That would seriously impact your security and reputation vis-a-vis your other customers. Instead of individual customer-led audits, there are much better alternatives available, which are basically your third-party audits, which are industry recognized, and whose reports you can actually submit to the customers. Again, it depends on what types of data we're talking about here, and what are the industry requirements that are imposed upon on the customer. So if there is no critical data, say, involved in the transaction, or if there are no overriding industry compliance requirements, as a cloud provider, you can reasonably point out that intrusive audits will only increase the cost to the customer and that there is no tangible value add to such an approach. Let's now move on to the next myth, which is regarding unlimited liability and how it doesn't and must attach to cloud providers for data security breaches. Now, it is common for customers generally to start out with this premise. But from a practical and legal point of view, this myth is clearly absurd. While cloud providers may not be able to eliminate completely their liabilities in certain types of situations, a review of the data protection laws in general suggests that there's no categorical prescription on how liability between commercial players must be allocated. Generally, the approach ought to be for the parties to take a very nuanced approach when it comes to the issue of risk exposure, and how you work out the indemnification, warranties, and limitation of liability clauses is how you basically allocate and the risk function. There is no blanket liability that the law actually imposes on the cloud provider. That's the real point here. Instead, the liability will actually turn on which parties actually contributed to a breach or a resulting harm. The law would generally try to seek to know whether the compliance obligations, let's say, of the cloud provider have been met, such as whether they followed up with information security and other applicable policies and laws. Now, this is one strong reason why I'd suggest cloud providers must actually have a very robust information security and other policies as part of their compliance framework. Now, this would not only fend off any concerns in the beginning of, let's say, when you're clinching a deal, but also it provides a very sound legal defense against transferring all liability when some unfortunate situation occurs, such as a breach or claim by third parties. So we have now come to the end of the discussion, but before we go ahead, a few thoughts to share in connection with how cloud providers generally may be able to proactively reduce their risk exposure. Now, this list of items is generally based on how customer expectations are evolving, and also how these practices may actually help you reduce your risk exposure. Now, number one, for starters, have a very clear terms and conditions or terms of use in place that govern the services and products that you offer. Also, two, in light of the growing focus on e-discovery, it's important that you offer search tools or other capabilities that would allow customers to locate data quickly and efficiently, especially in cases where, like, a customer needs to locate responsive electronically stored information, say, in a crunch. And you'd also want to assure authenticity and chain of custody of the customer data, and also ensure that the customer data is encrypted. And you would want to pay attention, obviously, to the format of the data. The metadata matters, because this demonstrates data integrity efforts on your part. Now, the third point I would like to bring to your attention is closely related to the earlier ones, and that is the importance of having transparent and clear records retention and backup policies explaining how data may be retrieved before it's potentially destroyed. This also leads us to believe that you must have a very robust security policy and actually convey it to the customers clearly. Finally, as someone who advises on intellectual property matters, I highly recommend that cloud providers look closely at their business process and technologies to determine whether there are any intellectual assets that ought to be protected. Now, this makes sense at two levels. By securing clear rights to your processes and technologies, there is less friction in the business relationship with customers on the underlying intellectual capital that you bring to the deal. Now, that lessens the likelihood of IP ownership disputes arising between you and the customer, or at least regarding the underlying resources being deployed. And In an increasingly competitive market space, I would suggest your intellectual property not only provides you an edge on efficiencies, but also to be a very valuable tool in the marketing front. Put it very simply, people tend to notice more favorably when you present your services as something that has the seal, let's say, of the U.S. patent behind it. Now, these are some of the issues worth considering if you don't have them already as part of your service offerings. So thank you so much for your time and consideration. I'm glad to provide any clarifications or answers to any questions that you have regarding these matters, and I can be reached via the email listed below. Again, thank you and good luck.